Okay, good morning everybody, and welcome to the 11 o'clock session, online session. Today we are covering project security with Henry Hathaway. As normal, your CPD certificates will come out after this, and if you've got any questions for Henry on this topic as he goes through, if you can put them in the chat box, which you can find in your toolbar. If you send them to me, Julie Camp, and I will make sure that he gets to see them all at the end and answers them for you. So without any more ado, Henry, I'll hand over to you. Thank you.
Yeah, okay. Good morning, everybody. Thanks very much for joining. This morning's seminar is in relation to project security, and what we'll approach is the different forms of project security in terms of if you're acting for the employer or how privity actually works between contracts. Over the last number of weeks and the last certainly months, if we include the different points of risk, including for Brexit as it was, and probably will persist again in due time. But certainly we've had this insurmountable change in the last number of weeks, which essentially has created certain risks towards projects. Construction was and is an environment that is prevalent with quite a lot of insolvency, cash flow issues. It's been that way for quite a while, and certainly with acting for incidents of insolvent or restructuring or administration, or certainly when a key party to a chain breaks down. The reasons are always quite familiar. They follow quite a lot of trends and patterns in respect of that. And of course, when acting for likes of funds or developers, these points become very prevalent, especially with the future rights. So where we have different stakeholders or beneficiaries, when we suggest, say, funds, or when we suggest the beneficiaries for proprietary interests in a project, about how do we maintain security against the 6 or 12 years? How does insolvency of an event during the course of the construction actually affect that? So in a lot of instances, these particular circumstances now are presenting a lot of inserted risks in relation to, we see it actually becoming quite prevalent in the next while. It's an industry that was already quite stressed in relation to cash flow and payment issues, and we actually don't see that in any way changing over the next while. In fact, we actually see it being exemplified by the current situation. So in terms of actually how projects that are currently underway or projects that are starting, and there are many, in fact, what are the different instances that in terms of project security to secure the actual project for not only now, but certainly in terms of 6 or 12 years under the Limitation Act. So if we look towards the idea to say, what is the need for security construction contracts? We look to the given positions in law relating to why and how it actually persists, including some diagrammatic instances of how a particular chain will usually present itself and where the chain of causation can actually be broken. Design liabilities we always mention in these respects as well, because it becomes incredibly important of the underlying performance of design and how the standard forms treat that, especially JCT. And we look towards what do the actual standard form contracts, key provisions and mechanisms say in relation to that as well. I thought it was quite useful because we generally as a law firm, we consistently see repeating issues and persistent commonalities within problems, the trends and patterns of how these actually arise. And therefore, of course, the difference between what are the third-party rights and collateral warranties, what are the difficulties, and what are the advantages and disadvantages of using either mechanism for that. And finally, then we talk in relation to bonds. We introduced the concept of bonds and what we actually see in relation to bonds going forward and how they actually are presented on the risks. But if we start right back at the very start, you know, and we actually look towards, say, why does this whole issue actually come into contemplation in the first instance? And we look back to the 1915 and the House of Lords, and it was certainly the privity rule and contract laws. It's fundamental, and it's explained by the House of Lords in Dunlop Pneumatic. And in the law of England, in essence, it says certain principles are fundamental. One such principle is that only a person who is a party to a contract can sue in it. And this is pretty much held law, and it makes quite a lot of sense. And I used an example earlier on that, like, you know, if we take it as most basic levels, that if there's two neighbors beside each other, one neighbor is having works undertaken by a contractor to its house, it's not for the neighboring party, if they're dissatisfied with how that contract's been performed, that they can actually sue or to have any rights under that. It's privity between the actual house owner and the actual contractor. It's their contract. There's no rights for that neighbor actually to sue on that contract, no matter how dissatisfied they could be with the performance of a contractor, or in particular the neighbor not paying, for example. So they don't have, like, no external rights. But what actually then becomes quite identified is that there ought to be other stakeholders, there ought to be other parties who are dependent, essentially, what they will actually benefit they will derive from that particular project or that particular contract in the future. So the doctrine protects a party against claims from strangers effectively, and there are commonly times when the parties to a contract expressly agree that some other entity is to benefit from the performance of that contract. So a good example will be property, for example, or any developments. We know that once the contract has been discharged by performance or otherwise, that there is a benefit for hopefully quite a long time in relation to that, either through proprietary interest or through a facility agreement in terms of fund, which other agreements will actually be directly related upon. So how do we do that? In general, we actually have, for example, the standard forms, and this is the danger when parties actually integrate without having addressed these points right at the time of formation of contract. And this is certainly the benefit of using standard forms, which are generally very heavily amended in respect of third-party rights or how they are to be exercised. But for example, under clause 1.6 of the JCT, other than such rights of any purchasers, tenants, or fund may take effect pursuant to clause 7A and or 7B, nothing in this contract confers or is intended to confer any right to enforce any of the terms of any party is not party to it. So essentially, bar the specified occasions where the beneficiaries are listed, and generally that's been the beneficiary has been a fund or a proprietary party with a proprietary interest in that, no other party may enforce any of the terms or actually sue on those points. And if we take it to a diagram, like, no, it's quite usual, and this typically, and this is very much a standard traditional format, so we can expect to see that if it was a design and build, for example, we might actually see this changing a little bit, where the contractor has many more parties in relation to design, for example. But essentially, on a standard building contract, you know, this would typify, and it would be very representative of how we would expect. So we see the fund and the first purchaser or tenant with those beneficial interests, hopefully in the future. We see that the employer is quite a key player, with a lot of parties actually falling through this entity. Obviously, the contractor, of course, being one party who undertakes the works. We have design elements. We have obviously the QS and the CA and employer's agent, perhaps, on those points. And of course, you know, they will be expected to exercise reasonable care and skill in the undertaking of their services. And of course, then, like, the contractor will, like in a lot of cases, then contract on a lot of the different elements of that point. So if we look at the employer, if the employer in this instance has been set up as what's called a special purpose vehicle, or its only purpose is really to realize the contract and realize the actual project or product itself, it's not uncommon for then this SPV to be dissolved or liquidated once it's performed its purpose, if you like. And that's entirely regular, and there's many reasons for that. But if we have a developed out project, and the employer does in fact liquidate itself or dissolve, having performed that purpose or function, and we're now faced with a number of years down the road, we have a whole host of issues for the fund, and certainly those with proprietary interests, if there has been a breach of the underlying contract between the employer and the contractor. One example would be defective works, defective design, all of those points. Because what we know from the House of Lords, and certainly within the standard form contract, is that if the employer does not exist, then the chain of causation is broken. So therefore, if Subcon 1 were to undertake its works negligently or not in accordance with the contract with defects, or in fact that there was some discrete design elements that failed or were defective in themselves, and the fund, or certainly those with proprietary interests as a beneficiary, would be deprived because that chain of causation, because ultimately they'd be expected then to act on the contract with the employer would act on the contract with the contractor would act on the contract with the Subcon 1. And that becomes impossible if you have actually taken the employer out. So that's pretty much the explanation. So what we now get into a point is we want to now, if you're acting on behalf of a fund or certainly working with a fund, and certainly in the next slide with the purchaser tenant, we want to create these collateral or side positions that if that event actually occurs, that we are not deprived of exercising our rights at some time now or in the future. And certainly that we can exercise those, especially in terms of the limitation. But we see now that we have the fund, which is linked up to quite all the entities. And secondly, that we see those different points. So in any event, if it's Subcon 1 who has created an issue in respect of defective performance under the contract, be it design or actual executing the works, the first purchaser tenant, or certainly otherwise, now has a recourse in respect by way of what we would call a third party or collateral agreement, and the mechanisms of how we actually approach there. So we can't talk about really collateral warranties or third party rights without talking about design liabilities. And certainly when we look towards, to say, the SBC, which is the standard building contract, the ICD, the intermediate contract with design, and the minor works with design, they inherently are not fully design and build contracts in themselves. They may have specific or discrete elements of design, which is covered under what's called CDP, contractor's design proposals, or portions within those particular contracts. But ultimately, they don't emanate to be a total design and build contract, and that becomes important as well, because ultimately the obligation on the contractor in those instances, regardless of the design elements and aside from design elements, is to complete the works in accordance with the contract. And certainly when we look towards that, is in completing the design for the works, the contractor is not required to take responsibility either for the contents of the employer's requirements or for verifying the accuracy of any design contained with the EEORs. Now, this is a clause 2.13 of the SBC, and you'll find that certainly within the design and build, that will actually be contained in around clause 2.10, 2.11. But ultimately what it says is, and there's a very good reason of how this is approached, and there's a pragmatism as well. that if an employer wants to have certainty on the pricing or what the scope of works are, they ordinarily may like to see their design team taking it up to a stage 3 or a stage 4 in accordance with the REBA criteria. It creates that price certainty. The design is undertaken to a very developed out sense. On the unamended form of contract, any designs contained within the EORs that are to be responded to with the contractor's proposals, the contractor does not take automatic responsibility for any of the contents or any inadequacy or any design contained within the EORs. This is relatively misunderstood within contract design formation. Certainly any subsequent designs that would be taken under those points would be. And this is where we see very heavily amended provisions being put into place with the standard form contracts, where most likely you would expect to see that an employer or a well-drafted provisions will be that the contractor will take full responsibility for all of the design contained within the EORs. That's a very typical amendment. But in the absence of that amendment, typically the contractor is not to take responsibility or to verify the adequacy of the buildability of those designs contained within the EORs. And certainly this is very much misunderstood. There is often representations put forward that this is a design and build, get on with it, certainly on how that actually is certainly communicated, especially in times of dispute. So certainty about design responsibility and obligations becomes incredibly important because, of course, this now has a liability, and it has a position that actually continues throughout, well after practical completion, for a period of 6 or 12 years. So the certainty about what elements becomes really important at this point, and it's not very well understood. And of course, like, if there is a benefit being derived from third-party rights or collateral warranties, the insistence upon these terms, they do have consequences later on. But this provision, when we look towards 213, the SBC, it appears to have been intended to counter the possible implications of a 2002 case with Cooperative Insurance and Henry Booth, where it was held that a contractor required to complete design work was under a duty of care to examine an employer's pre-existing design and to satisfy himself that it was such that it would produce a completed design that could be built. So inherently, these provisions now actually counter that. And you'll see that JCT has always evolved over the years to counter these points that have actually come into court. So if I look towards, a side note with relevant events or relevant matters, or especially relevant events, to prevent time becoming at large, under ruling of Peake versus McKinney, back in 1971, they inserted clauses such as any impediment, prevention, or default. So those type of clauses were brought into JCT in response to actually how the law developed, and it's a very, very much sophisticated set of circumstances. So this will counter one of the reasons. But on the unamended form, the responsibility for the EORs, and this is quite important for employers to actually understand. And especially while today we don't talk about novations or how design responsibilities then change over, it does become quite relevant. But if we see also, the contractor is obliged to notify of any inadequacies in the EORs on becoming aware of them. So if they do become aware, there is a positive obligation that they actually have to see to highlight the inadequacies. And therefore, there are 3 different events then that come into play there in terms of risk. But if it does qualify, the EORs would have to be corrected and instruction actually provided in that respect. And then the variation to the EORs under the contract to produce a variation. And this is commonly a source of disputes between parties. As to exactly that point, who is responsible for it, and these certainly give the answer. It's incumbent on the contractor to ensure the employer's design complies with any statutory requirements in all events, and certainly we have defined terms in relation to that as well. So it's open to the employer to delete and amend both provisions. It's a very, very common amendment. In fact, I can't think of a time that I was acting for an employer or developer that I have not actually reversed these points, and I have not allocated the risk in those certain instances about design responsibility. It's a foreseeability issue. Generally, it's well tested, and what we're actually trying to put forward, it can present a significant risk depending on the development of those designs. But again, the key point about this is that if we've reversed the risk allocation and have put forward under an amendment that the contractor is responsible for all of the contents of the EORs, then of course that now becomes very much a provision of the vehicle under which a collateral warranty or a third-party right will actually now present itself as a long-going on liability, if you like, in relation to that, even though those designs might have been undertaken by others. So we generally feel that there's not enough interrogation at this point of tendering or formation of the contract, or what the residual effects can be for time spent. Because of course, when we now talk about third-party rights or collateral warranties, these elements now become very, very important. So the interrogation, or to understand the relationship between a positive duty to inform of inadequacies, or certainly whether there are any rights to actually actively look for problems, which we've already looked towards and we've already dealt with. But these are particular issues that the industry faces. Generally, tendering occurs over the period of 4 to 6 weeks, or it might be longer, it might be shorter. But these are the intense pressures, and if we're talking about liabilities persisting over a course of 6 or 12 years, these points, we really do have to understand what we're actually introducing at that stage as well, be it inadvertently or not. And this is the detail that actually goes into what is actually the review of the terms and conditions at the time. The employers will commonly seek a chain of amendments to recitals and to the above provisions to reverse this allocation of risk, namely to make the contractor responsible entirely for the design contained within the EORs. Contractor is required to undertake any design work to the standard expected of an appropriate professional consultant, such as an architect or consulting engineer, appointed directly by the employer, not undertaking any construction work. So we're now into what's in, and it's expressly stated as being the like liability clause. And it's really, really important that contractors, when undertaking these type of works consistently, especially in terms of design, is this the nature of their business? Is this what they consistently do in design and build? But if this is a once-off, then the aspects of such as PI in respect of professional indemnity insurance in respect of design works, what are the plans in future or keeping with this, and certainly the commerciality of any particular elements of the PI itself? So we have particular habits and behaviors within the industry that we feel that once we reach practical completion, that's the end of it. Certainly not. So the overall framework or constitution of companies and how they actually behave and what they actually persist within the industry really does come to the forefront when we look towards these points. The contractor is required. Okay, so like we talked about the like liability. But if we now look towards, say, the SBC 2016 again, we look now towards the contractor's design documents. And they're defined in the contract as the drawings, details, and specifications of materials, goods, and workmanship, and other related documents prepared by or for the contractor in relation to the contractor's design portion. The contractor's design submission procedure is set out in Schedule 1. It sets out a submission, approval, and communication system in relation to the contractor's design documents. Now, it really actually now becomes the last point, because something as well, and this becomes very much, if we're a party that we're acting on behalf of a fund or somebody with a proprietary interest, we don't necessarily want to be looking at partial defenses coming later on down the line about, well, we submitted our contractor's proposals, and we're now going to rely upon certain recitals to say, well, the contractor's proposals have been examined by the employer and they appear to meet the employer's requirements. And that, again, is always, we've seen that as a partial defense put forward. The key point about it is that it is actually appear to meet. What's important actually is within the schedule itself, once we mobilize those, that the acceptance or the procedures put forward, it doesn't absolve the actual design responsibility placed upon the designing party. So ultimately, that is a careful point. It's not really on behalf of those who are consultants on this forum this morning, it's not really one that I would be inviting later on. These are disputes that ought to be avoided. We're talking about certainty, about terms, certainty at this point in time, for the very reason that they ought not to be a subject of debate, especially when they're so foreseeable in many of the disputes that we deal with time and time again. So if we look at standard form contracts and the key provisions and the mechanisms related to there as well, I want to talk about sort of interpretation and the precedence of documents. These are issues that we will often see as being put forward into difficulty, because ultimately when we talk about third-party rights, we talk about collateral warranties. That's the vehicle. It's the underlying document that is still the contract. That's performance. That's the expectation reliance and whether or not that's been discharged or not. We're asserting at some point in time in the future that there is an issue, and that there has been a breach, or the works have not been undertaken in accordance with the contract. And so when we actually get very much amalgamate or different viewpoints on that, but at common law, a contract will generally be construed as a whole, i.e. the conditions and documents will be read together. And this is really a general point of law. And we have to look at how that's actually treated within the JCT, for example. And yes, the JCT does make reference under clause 1.3, which is a very small, innocuous clause, and it can be readily missed. But it is a very key clause in relation to what it actually says. It says that the documents, the contract is to be read as a whole, but nothing in the EORs or any of those particular documents or designs, nothing is to override the conditions or disagreement. So we're into a hierarchy straight away, that where we have a lot of different points where employers or certainly their consultants will insert quite a numerous different amount of terms or terminology or conditions as they see it into the employer's requirements about the performance of the works. They must not offend the actual conditions, the conditions being through sections 1 to 9. They must not offend those, because the hierarchy of the agreement and the conditions will prevail over that. And that is a key difference that actually reverses and is expressly agreed between the parties in respect of how it changes from the general rule of common law. But where there is an ambiguity, the courts through the common law case law have developed certain principles which they apply as an aid to interpretation. The rule of construction that greater rate should be given to conditions that have been specifically drafted against those which are of standard nature, type over print, for example. So we're now looking at sort of manuscript amendments that the fact that parties would apply their mind specifically to this, and it must be more persuasive. But again, this is a rule that assists rather than, it's not something I would always be perhaps suggesting to parties that they should go straight for. The idea is to get these points right from the outset. It's an aid, it's not a given rule. And that's where I would sort of suggest it. So in some standard forms of contract, such rules of construction are circumvented by express terms of the contract. And again, I'm back to clause 1.3, which becomes very, very prevalent. And it's very small, it's an innocuous clause, but its weight is very, very effective. But the general rule is handwritten over typewritten over printed. But the hierarchy of documents, including common amendments to the standard form. So I'd expect that a lot of amendments, and certainly when I'm drafting, I'd expect to see the hierarchy. I'd expect that most documents, especially that have been drafted by most practitioners will actually set out what the hierarchy is, so that if there is a debate or if there's a conflict in the future, that certain items are given certain weight. This needs examination at the time, and we've often seen contractors getting themselves into all sorts of bother because they might put their list of clarifications appended on to a contract sum analysis or bill of quantities. It's very regular for that. But how does that interrelate between the conditions and any other documents in terms of the hierarchy? So the common problems that we see: errors and inadequacy in the contract bill and the CDP documents, in and between documents generally, and in between documents relating to the CDP. So we see quite a lot of those different instances, the conflicts that arise between the actual those documents themselves. And for one point, I would always suggest that two versions of a drawing revisions, wrong version is signed. Contract drawings lists do not correspond with the drawing signed. There's another issue we commonly see: the failure to complete the contract documents, the failure to complete the formalities. And essentially now we have real difficulties here because, like, no, we can say, we can usually see what the course of events and how something has happened. So if we have a T2 or T3 in tendering, and the wrong version is incorporated as the contractor might have intended, the duty really is on a contractor to check all of the documents, and especially if they've signed a T3 version, but they had actually tendered on a T2 version. There will be little sympathy in that respect. They face a huge uphill challenge in respect of why was it that they initially signed those drawings when in fact they had tendered on a T2 version. And not only that, but the actual versions have been incorporated adequately in respect of the contract. They face a huge insurmountable battle there. And the prospects of now arguing that there was a mistake, either be it unilateral, common, or mutual, is very, very, they'd face challenges. They would have to go through all of the different points. When in fact, one might say, was it not quite that little bit easier at the time of contract to actually have certainty over those points? The failure to complete formalities, we often get asked, like, no, and this again persists in points of view of if we're looking at third parties, in respect of what happens if we don't sign a contract, what if we don't execute? How is that actually to prevent performance? Are they bound? And you can bind yourself by conduct. As to the insistence or the points of how parties would be bound to either 6 or 12 years under the Limitation Act is a completely separate question, because obviously, like, the details of the express provisions, and as well as executing validly as a deal and delivering that deed, which is always a requirement as well, of whether or not they have actually been affected. But you can bind yourself, especially if it can be demonstrated that performance was in the state of play. And if conduct does bind a party, it's more than likely not. Remember, in this instance as well, the courts generally do not like an argument to say that there has not been a contract entered into by both parties. And meanwhile, that there has been payment and there has been certainly development and there has certainly been a product. So there has to be simply some contract. Maybe it might be in dispute as to what the exact terms were or the common intention, but most likely not that there will always be an agreement at some points as well. Again, we get into different arguments and failure to complete the formalities. But what if I suggest that one party will execute as a deed validly and the other party doesn't execute as a deed validly, or in the execution blocks? Like, we know the effects of, like, 12 years versus 6 years. And how does that actually then affect the binding nature of where the parties would actually see it? So moving towards having gone through the first principle points, if we go into what the actual 1999 Act, the Contract Rights of Third Parties Act 1999, essentially, this was brought in response quite a lot, where third parties do want to derive a right, or beneficiaries, or have a beneficial interest in the performance of a contract. And this has been very, very slow. It's 1999. It's been incredibly slow to be adopted within the construction industry. We're talking about habits and behaviors. The general perception is within construction is most parties do prefer still to maintain collateral warranties. And there's numerous different reasons for this. I think that the physicality of having that actual executed document. Funds have often made comments, if you like, on the effect of step-in rights in relation to the express agreements. But ultimately as well, I think a lot of it comes back to what the parties actually persist. I think a lot of the trends, the patterns, behaviors, it's what parties are used to. It's not without its problems, and certainly when we look towards and acting for a vast array of all of those in the chains, they always present a lot of issues of how they're executed, how they're delivered, and what the actual contents are, which may affect for later on. So if we look towards the third parties may achieve entitlement to an enforceable benefit through either two routes. First of all, where the contract expressly states that they may enforce a term in their own right. Second, where the terms of the contract purport to confer benefits on them, provided under section 1.2 that it cannot be construed in proper construction that the party to the contract did not intend the term to be enforceable by others. 1.3 provides that third parties may be identified A by name, B as a member of a class, or C by description. They need not be in existence when the contract was entered into, and this actually becomes very relevant in construction because we see the pragmatic points and how construction actually occurs, that if you're a purported beneficiary, it's unlikely that a contractor would know who the subcontractors will be at that stage. So therefore, these elements therefore do very much help. So like we can actually inform the drafting at this stage as to how, for example, a class of activity, substructure, superstructure, cladding, M&E, and certainly the relative disciplines can then fall into those instances. So if we look back to, say, for example, section, and we're still with the Act at the moment, section 1.5 gives the qualifying third party the same remedies as he would have had if he was party to the contract. It's provided by way of a notice between the parties to the contract that rights will be conferred upon the third party. It's very simple. There's no set position. The notice is very straightforward, that you are conferring notice under that. The key thing really here, and this is where we find that we do have difficulty, is whilst it might usually be the case that between funds and developers and the main contractor will generally at the early stages have the drafting within the amendments or within the actual contract to confer these rights expressly stated. The difficulty can be about the step-down clauses between contractors and subcontractors, and therefore the ability for a contractor to provide notice that the beneficiary will. We see this as a prevalent issue anyway, and it's a problem overall for third-party rights in any event, because incidentally, if a fund or a party or beneficiary with third-party rights really want to enforce the terms of an agreement, one must now look really as what is the quality of the agreement between the contractor and the subcontractor. So what provisions are in place? Is it under a standard purchase order? All of those things really, really matter now at this stage. And the collateral warranty is a vehicle, or the third party rights side, it's a vehicle for constituent parts of that contract, the quality of that. And we sometimes feel that those persisting rights along the chain has not been dealt with adequately enough to ensure that the overall security has been provided for the times that's required for. So if we look towards like now the schedules in JCT, what does the schedules in JCT provide? So we're into Schedule 5, Part 1, and essentially they're providing that they include rights granted by the contractor as being works to comply with the contract and good practice, to contractor's liability, no rights to take instructions, use contractor's design documents, professional indemnity, assignment, giving a notice. So they're very well contained, and for some reason I always feel that the schedules within the JCT are somewhat not always engaged with to the full extent. And even when you see a lot of drafting, anybody on this forum, you will often see that there is a very heavy amendments made towards Section 2 and Section 3. But then it drops off. When we get to Section 7, we don't see as much amended drafting, or we don't see as much at all. And that's quite a pity. I'd even say that about termination clauses. I feel that they are the positions to engage with. They really do engage with points of future obligations. They really engage with when things go wrong. And I think that proper drafting and proper construction of contracts is the foreseeability that things can go wrong. And that's what we're trying to fix. We're actually trying to look inherently at the project rather than a simple, straightforward risk allocation, in itself, but identify with the uncomfortable questions about when things go wrong. When we look at Part 2 of Schedule 5 under JCT, the major difference, of course, is going to be it's on behalf of funders, and what we have is the step-in rights. Of course, that's identified. So in a lot of ways, this Part 2 is specifically, and that's the key difference on that point. When we look at collateral warranties, which is the other mechanism, and this is the mechanism that most people will be most familiar with. This is the stage and time of a project. We're coming up PC, practical completion, and at this point in time now, we have a lot of parties who, especially with the fund, the developers and the consultant team, rushing around at this stage now to try and ensure that they have a full set. Usually because of the condition of the agreement for lease or facility agreement for payments, etc. And it's generally left far too long, far too late in a lot of our experience. But when we look at, say, the employer may want the contractor to grant rights of purchase tenants of the fund, but by way of collateral warranty, and it might want to do so with the subcontractors under Clause 7E. Collateral warranty is no more than an obligation to enter into a separate agreement upon specified terms. This today is the most common and tends to cause the majority of problems, really, and most of them are operational. I've already discussed about that. If we don't have a very good quality of contract or terms of contract between a contractor and a subcontractor, that can present problems later on. So what is the quality of the terms, the design? And ultimately, I feel that we're in agreement for leases and facility agreements for funds. Sometimes they do, but not always, make good reference to those documents they may rely upon in the future, especially if the employer is not going to be a party to it. And all of the time, there seems to be so much emphasis and effort put into the agreement with the employer on those points. But if we're now relying upon a third-party position later on, I think that the same intensity and same application needs to be provided towards those step-down clauses, of course, as well. This today is the most common, and it certainly causes the majority of issues. But while it's triggered within the contract particulars, procurement and delivery of such agreements can lead to difficult processes. So when we look at why do we suggest that there is a difficult process, I think that there is on a realistic level, I think that the time, regardless of all the reminders and the advice at the time, there seems to be a habit where these are documents that everybody thinks about in your PC or at the end, which is quite late on the process. And that in itself causes improper applications of bargaining, if you like. certainly we have contractors who's coming up to a final account position and sometimes, and improperly and not for the right reasons, they might use some of these instances as leverage. And there's no rights persisting under that either. The difficulty really stands that under the current standard form, one has to ask, it might be an obligation to, especially in the particulars, but what if a contractor or any other party refuses to execute and deliver? And if that's the case, then what's the sanction? Because there really is no given sanction on the face of it expressly. Now, a party might suggest, well, does form a breach of contract, and they've expressly stated that they will provide these in executed form and will deliver. But those rights would ordinarily be under common law. So what's the loss? You would have to provide the loss. These are difficult arguments. So generally, we introduce quite a lot of amended formats to provide those sanctions, either be it financial or otherwise. And I know in the earlier course of this morning, it's not unusual to have certain clauses that power of attorney clauses can be actually expressly put forward as well. But it is a difficulty, and it's understanding. And the key question really is, if we are going to struggle, and if we struggled in the last 4 or 5 projects to actually take hold or procure these documents, well, it's foreseeable that they will happen in the future. So what are the different events that we have to actually ensure that we do? But there's practical issues as well. There's practical issues in how the documents are actually put forward and how the actual chain of events. It's not unusual that it presents difficulties. If we're talking about a fund being involved, we're now talking about 3 separate documents about the beneficiary, the fund, and the two other parties in the fund as well, because it's step-in rights. The promise given by the contractor and the warranty is given as a practical completion, so the request can be made up to and following practical completion. So it's the instance, and we see that most instances, of course, where liability occurs for the contractor is at the time of practical completion. That's when, so any rights of action persist from practical completion in respect of defects. Most in the industry will understand the difficulty in procurement, and if the contractor or any other party does not enter into the required warranty, then clearly no benefit can be enforced. It simply doesn't exist. So, but we do see that the express terminology is a financial point, which obviously is a valid ground in respect of a deduction of sums. Is there any other rights that can be put forward? But we kind of get interested as well in how these documents are actually presented. Have they been completed, for example? A lot of these are appended in the appendix of the original agreements, but how do they actually become completed? They are a vehicle. Common issues are, what I would like to see is, have they been executed in wet ink by each different party? Is there a counterpart clause, or how are, ultimately are these documents that has to be transferred each time? I don't particularly want to see the first party, usually the contractor. I don't want them to see dating the agreement. Usually it ends up at the end with the beneficiary being the last party to execute. And of course, the dating becomes a real issue. Other than that as well is that it is a requirement, if they're being executed as a deed, that they have to be delivered as a deed as well. That's one of the requirements. So all of those different points, and of course the valid execution as well, often causes issues with that. So when we go to the first instance, okay, so third-party rights versus collateral warranties. Why is this an issue? What are the benefits of each? What is the difficulty as an industry that we continue to remain so traditional? And if we talk about enforcement, one of the points I mentioned earlier on was, if we fail in the instance to have adequate drafted clauses between a contractor and a subcontractor or any other entities for that matter that would confer a right under the Third Parties Act, then any notice, what is the notice against? So realistically, this all emanates from the very, very start that those provisions have to be put in place. The quality of the actual subcontract itself as well. If we're contracting on the basis of a JCT on a main contract basis, under either be it design and build or ICD, these forms of contracts do have their requisite step-down subcontractor points, but we still find in the industry that we don't actually invoke those. So therefore, if there is a design responsibility from the subcontractor, what is the standard of care? What are the different points? So the step-downs of those, we really do see as being an issue. If it's like, we do still see purchase orders being sent with no given terms or conditions, and how do they relate back to the actual security of the project itself, okay, and to underpin the performance of that. And it's for all the time and effort, and dare I say, costs that are involved between a fund, beneficiaries, employers, and contractors. We really do have to make that much more of an effort to understand that if we are deriving a right from a third party, what's the quality of the documents and the quality of the terms that may or may not be relied upon in the future. And I suppose the irony from experience is that the better the quality of the documents underlying or being stepped down, conversely, like the lesser disputes sometimes, and it demonstrates the application of how these projects are being run as well. But essentially, enforcement can be on those points, so to make sure that they are stepped down properly. The ease of obtaining, well, of course, on any given aspect, a simple notice given in the third party's rights is it. Of course, you know, it's not unusual in terms of collateral warranties to have couriers traveling the length and breadth of the UK in respect, and you know, and then they might even come back wrong. But certainly these, you know, the ease of obtaining, and it's much easier in terms of simple notices. Careful drafting in terms of any fund step-in rights can be affected in themselves. Again, as an industry, we're quite behind on this point. Reduction of administration between producing engrossments and gross forms, delivering execute documents. But ultimately, we are sort of looking at habits. It's whether it's the physicality of having those solid documents and engrossed form properly executed or not. It is a nature. So every single thing that we see in construction is formed of habits and behaviours, and a lot of that will relate back to parties believing that they just feel that bit more comfortable with them. So if we go into now just to discuss briefly and in relation to bonds themselves. We've now entered into, as I said, and it is really foreseeable in the future that this is an industry that faces quite a bumpy road over the next while. In fact, the whole economy is facing challenges in every sector, I expect. But certainly from a lot of the feedback, we have always been in an industry where cash flow problems have always persisted. Any type of global events certainly will highlight and exacerbate those issues in most given circumstances. Previously, of course, bonds have always been a discussion point. The expense, of course, and the rates of which they're called upon have always been matters coming true. That position really became exemplified following Carillion, especially when we're discussing, say, under clause or section 113 of the Construction Act itself, and we started dealing with really uncomfortable questions about the upline insolvency events that's held under the Construction Act. So those lower down on the chain becoming quite affected. So while on one hand, a pay when paid clause or pay when certified clause for outlawed. Within that same provision, we now had difficulty with upline insolvency because it's contained within this clause. So bonds started becoming very much after Perillian, and that was one of the real discussion points at the time. But it's to describe and discuss then, like, how these become prevalent or what's going to happen within that as well. So in terms of the different types, there's many different types. We've got the bid bonds, performance bonds, which is generally what most parties in the construction industry would align themselves to, retention bond, and how that's dealt with, or PA, which we wouldn't certainly have much interaction with, or the HMRC bonds themselves. But if we're looking at advance payment bonds as well, it's very usual that Highways Act bond would be undertaken, especially if there are works in the highways, waste operators license, and pension bonds. The majority, if we have two different types, we have the insurers, the likes of HEC, Aviva, banks, HSBC, Lloyds, all of those. But one particular point in time, and while we're not here to suggest yes or no, but one point would always be to be aware of is the offshore provisions. Whether, what is the due diligence? Because percentage-wise on defaults with performance, but again, it underpins what's been underwritten. So any challenges to the wording, any challenges to the underwriting of any particular bond, it is always worthwhile that the rating, in particular, who the bond provider is, who's underwriting it, becomes very important. For those offshore bonds, there can be a little bit of temperament in relation that if you were to enforce the terms, you essentially would be enforcing the terms out of jurisdiction. Which could lead to a lot of different points. Meanwhile, the threat is occurring real time in this jurisdiction, so it can cause those issues as well. So it's very much due diligence and proper good advice in respect of that. And I think that is both parties. I think that is those who are seeking the bond, and those, of course, who are actually procuring the bond as well. So is it sure to your bank? So banks, in terms of what they're looking to require 100% collateral assurance at the starting point, zero collateral, bank issued bond wording are always on demand. So on demand, if we're looking at no, you do not have to prove that default position. It is an on demand point. No, if we're going into a performance point of view, no, well, you're going to have to go in and demonstrate the breach, and that's the conditional basis of that. So we'd often say that banks will retreat from surety, but still dominant in UK and Ireland, and sureties have strong credit ratings and market share is steadily increasing. One of the real differences is, for those who've ever experienced any projects in the United States, for example, it's actually the surety industry which has a really heavy influence on the management of the actual projects themselves, and there's certainly interest are always put forward. Well, if you look at conditional contract guarantee bonds following the underlying contract and are triggered by a breach of the contract, including insolvency. Now, insolvency, of course, has to be an express term for a right to breach a contract. Insolvency in itself under common law may not actually give rise to, say, an event of termination itself, but that's why you see so much effort being put into standard form contracts to actually detail out the insolvency under Section 123 Insolvency Act 1986. On-demand bank guarantees do not follow the contract per se and can be triggered on the beneficiary's request. And that's really the aspect of it. For performance bonds, they should be avoided as per the Association of British Insurers. And then last point is the ABI model bond forms. Okay, are seen as pretty much that the most parties will actually, this would be one of the starting points really. It's seen as equitable for parties. Amendments can be negotiated, but however, as I've often found out myself, that when I go in and heavily amend the standard provisions, it can drastically influence the premium. So one has to be very careful in what amendments are being proposed and what's quite right and forward to put forward. And so in general, we have the likes of different information. These are type of information that I would like to see parties and maintain pretty regularly, not just in these type of events. Ultimately, as well, and it's not part of this discussion this morning, but like talking about behaviors and talking about habits within the industry itself, but it's actually how parties actually see themselves or how they present themselves on that they're, what is their gearing, what is their debt ratio, debt equity ratios, all of these different points, and makes them very, very presentable and willing to buy in. This is, of course, relevant to banking and insurance and the performance as well. So certainly there are those different points, and they're just really to be kept up to date, and they certainly do influence how the procurement or ability for a company to procure those points in time. Okay, well, thanks very much. And now there's a couple of questions before to conclude. And there's one particular: if a contract was intended to be a deed, has been incorrectly executed, is it by default to be deemed to be executed underhand? Well, the simple answer to that point is it best it ever can be is by underhand. Any contract that was intended to be executed as a deed, if it's not executed validly, and there's many different ways. So first of all, there's 3 different ways. But if the execution block, if it doesn't set expressly that it's supposed to be a deed, for example, which is very unusual, but if it didn't express that it was, that would be a problem. That's why I always see that, like, no, as a deed, executed as a deed on top of the title block. But also within that, if, say, it's not an officer or secretary, or it hasn't been witnessed, or the witness did at a separate time, the best it can be is for a 6-year liability underhand. That's the best it can be. The difficulty actually really arises, say, if one party, and this is where parties really need to concentrate. For some reason, we just take every different position. We get an executed form of contract back. There's a scribble in the signature box. The verification process of that, okay, because it's not unusual, and I'm pretty entitled later on, if I take those documents that other parties have dealt with, I will want to check that that's an officer of the company. I want to check that it's validly executed as a deed. So, for example, I would like to see for completeness, not only a signature, but I'd actually like to see the name in print as well. It's very hard sometimes to read signatures at the best of times, but I want to be able to check, was it validly executed? Now, if one party validly executes and the other party doesn't validly execute, then you might have a really strange position, whereas one party has executed validly as a deed and are bound as a deed, whereas the other party, the best it can be is 6 years. And that's an incredibly dangerous position, because you've created a gap. And a completely different set of arrangements. So that's quite a difficulty. But in short answer is, the best, if it's not validly executed as a deed, then it won't be a deed under the Companies Act 2006 in that respect. And that's the given provisions as under the Companies Act at the moment. Next question then: do you expect in post-coronavirus reality to see increased demand for bonds from clients? Many subcontractors may be financially affected, and bonds, collateral warranties may be expensive. Would it make third-party rights more popular? Yeah, I think that the security and surety point, I think the first key thing, and certainly what I've been seeing, and I act quite regularly in certain matters relating to exactly this point. In terms of the expense, of course, with bonds is always going to be quite one of the instances. Remember as well that these are points that are discussed at the time of contract. Nobody goes into contract, or ought not to, in believing that there's going to be an issue in relation to insolvency or these different instances. So whether or not we might look at different points like insolvency bonds, you probably see more inquiries as to whether or not that's the solution. In my mind, it doesn't provide. I pretty much like to go right back to the very start and actually underline, because even if you are a good payer, like if you're acting for an employer and your payments are quite good, quite regular, you now are in an environment whereby if there's 3 or 4 different contracts, nothing to do with you, but if they're not paying, they now have an influence on the viability of that particular company. And we're talking about a solvency issue here. And I don't think many parties, but we've often seen parties who have been exercising really good trading history, and in the space of 6 months or even less, that they can really get into these positions really, really quickly, all on account of 1 or 2 problem projects. So I think due diligence becomes really, really important, because to understand that when you're contracting with a party, to understand what is actually happening with that company. We know the credit checks only give a limited amount of information. So therefore, while we'll probably be up to date, in terms of any debentures, all of those different points, but those real things that's happened in the last point in time become really, really critical. And when we actually look what's happening, so this is an environment that's changing day by day, or not week by week, but it's changing really, really quickly. And certainly we expect that where a lot of parties had a lot of orders, their order books were full, that might change very, very quickly. Parties who were ultimately very, very good at payment under contracts, their hands are forced in some instances. So I'm more concerned about, not so much about, I'm concerned about the reality about how it's actually happening in the environment within a quick space amount of time. Performance bonds which underpin the performance of the contract, etc. Yeah, absolutely. But I think we've actually, to get into that event, we're actually dealing with something a little bit more hard hitting. I think it actually comes down to with cash flow. So certainly, how parties engage and how they actually see that, it will become really prevalent now, and it always has been. But I think it's just this whole environment now is going to really exemplify the current issues, and they're going to throw spotlights on the current problems and really exaggerate them. Okay, thanks very much, everybody, and I'll hand you back to Julie.
Okay, thank you very much, Henry, for that. Thank you for answering the questions. Thank you to everyone for logging on today. We will shortly be releasing details of further seminars for May and June, so keep your eye out for that. Sign up to the newsletter if you haven't already done so. But otherwise, we'll see you all again soon. Please stay safe, and thank you for logging in today.